Hey everyone, and welcome to this explainer. Today we're diving into a genuinely fascinating case from the Supreme Court of Nepal, Chandra Bahadur Mabo versus Lakh Bahadur Mabo. Now, at first glance, this looks like your standard run-of-the-mill real estate disagreement. But as we dig into it, it actually reveals some incredibly strict and honestly almost surprising rules about property rights, the mechanics of advance payment deeds, and how contract law literally works in practice. So let's get right into it.
So let's set the scene. The backdrop for our broken real estate deal is Panchathar. On one side, we have the buyer, Lakh Bahadur Mabo. On the other side, the seller, Chandra Bahadur Mabo. What started out as a simple everyday handshake agreement to transfer some land quickly morphed into a massive head-on collision between a private contract and the formal legal system.
Okay, let's dive right into the core of this, because the absolute heart of this case is a question that applies to almost any major transaction you or I might make. If a seller backs out of a deal, do you automatically get double your deposit back? It's a super relatable scenario, right? And as you'll see, the financial stakes in this entire case hinged entirely on the legal answer to this exact question. All right, to really understand what's on the line here, we've got to talk numbers. 125,000 rupees. That was the total agreed price for Chandra Bahadur's land plots, specifically plots number 68 and 69, located in Tharpu VDC. This number right here is our baseline. It's the ultimate prize that both parties were circling.
Now, here's where it gets really interesting. Out of that total price, Lakh Bahadur, the buyer, made a massive upfront commitment. He handed over a crucial advance payment of 75,000 rupees on the date 2057-09-16. I mean, this wasn't just a small token of good faith. This was well over half the total price. But there's a major catch. The deadline for the remaining amount was set for just 2 weeks later, on 2057-09-30. The clock was ticking, and it was ticking loudly.
And boom, this is exactly where the whole thing falls apart. We are suddenly looking at two completely opposite stories. The buyer claims he actively went to pay the rest of the money before that strict 2-week deadline, but the seller just flat out refused to accept it, supposedly because he was looking to sell to someone else. Because of that, the buyer demanded double his deposit back, a hefty 150,000 rupees. But the seller's reply? He paints a totally different picture. He insists the buyer simply missed the payment deadline altogether and calls the entire claim completely baseless. What should have been a super quick 2-week turnaround morphed into this agonizing 8-year legal saga. The progression is just wild. It starts with the initial signing in 2057, moves through the local VDC, advances to the district court the very next year, hits the appellate court in 2059, and then drags all the way up to the Supreme Court in 2065. Talk about a marathon. So where did this 8-year marathon actually begin? Well, the very first stop the buyer made was at the Tharpu VDC, the Village Development Committee. He went straight there to formally complain that the seller was ignoring him. But here is a massive detail that becomes a real game changer later on. The seller never showed up to the VDC when called. He totally ignored them. And that failure to appear completely set the stage for a crazy game of legal ping-pong. First, the Panchathar District Court looked at it and completely dismissed the buyer's claim, threw it out. But then, the Elam Appellate Court looked at the exact same facts and ruled entirely in favor of the buyer. We literally have two courts with two completely opposite views on who was actually at fault in this broken deal. You might be wondering, how do they disagree so drastically? Well, the Panchathar District Court's logic was actually pretty straightforward. They essentially told the buyer, look, you can't just say you tried to pay. Where's the hard evidence? They reasoned that if the seller was genuinely refusing the money, the buyer should have formally deposited those remaining funds directly into the court to absolutely prove his intent. Without taking that step, legally speaking, he had absolutely no right to claim the double penalty amount. But wait, then we get this shocking reversal from the Elam Appellate Court. They focused on entirely different details. They pointed out that, hey, the seller actually accepted that the agreement existed in his written response. Plus, they viewed the buyer's application to the local VDC as solid proof of his intent to pay. And most importantly, they decided that the seller breached the contract simply by ignoring the VDC's summons. Because of that specific logic, they actually awarded the buyer that massive double compensation of 1,050,000 rupees. Talk about tension, right? With the lower courts completely locked in a stalemate, it was time for the ultimate tiebreaker. The Supreme Court of Nepal steps in on 2065-01-16 to finally settle the dispute, review these completely contradictory lower court rulings, and, as we are about to see, establish some truly sweeping legal precedents for everyone. Now, before the Supreme Court dropped the gavel on their final verdict, they actually called a quick timeout to clarify a couple of foundational legal concepts. First up is the idea of baina bata. Simply put, it's an advance payment deed. But the Supreme Court emphasized a really critical nuance here. Its primary purpose isn't just to act as some tricky penalty clause to trap someone into paying double compensation. No, its primary goal is actually fulfilling the contractual obligation itself, which, in this case, meant executing the land registration. Execution is always the primary goal. Compensation is purely secondary. And then there's the second critical concept the Supreme Court zoomed in on, Tali Durant Starhut. This translates to the act of depositing the exact remaining funds into the court. The Supreme Court leaned heavily on past precedents here, specifically calling out a case known as Tirtha Kumari Rana versus Ram Shankar Shrestha. They used this to prove that a buyer literally has to put their money where their mouth is. If you claim you are ready to pay, you must prove your readiness and willingness by formally depositing that cash with the court. Just making oral claims? Yeah, they just don't cut it. All right, moment of truth. That brings us to the final verdict. The Supreme Court firmly, absolutely sided with the seller. They completely overturned the appellate court's decision and reaffirmed the district court's original dismissal. What does this mean in plain English? It means the buyer walked away with zero compensation. Nothing. And, to add insult to injury, the court actually ordered the buyer to pay the seller's court fees too, which totaled 4,911 rupees and an additional 640.50 rupees. So what does this all mean for us? Let's quickly summarize the massive legal takeaways established by this case. Number 1, going to an unauthorized body like a VDC has absolutely no legal significance. They simply lack jurisdiction over these types of transaction disputes. Number 2, oral claims without hard, documented evidence are completely insufficient in the eyes of the law. Third, and perhaps the biggest takeaway, the doctrine of reciprocity is absolute. If you want a remedy, your proof of readiness to perform your side of the contract is strictly required. You absolutely must prioritize the execution of the deed over seeking secondary compensation. Which leaves us with a really powerful provocative thought to take away from this explainer. Are you truly ready to perform your own obligations before demanding compensation from someone else? This case serves as a massive reminder of the true reciprocal nature of contracts. You simply cannot demand the law to work in your favor if you haven't flawlessly executed your own side of the bargain. Thank you so much for joining me today to unpack this